Figuring out the laws around family property can feel like you're trying to solve a really complicated puzzle. It gets emotional, it gets messy, and honestly, the rules are often not what we think they are. So today we're going to untangle one of the biggest knots by looking at a real-life court case.
This is the question, isn't it? The one that's torn so many families apart. Do you actually have a legal right to your grandfather's property? Now, you might assume you have an automatic claim, but, well, the law might just surprise you.
So to really get to the bottom of this, we're going to walk through a fascinating case that recently went through the Delhi High Court. And the great thing about this is, it isn't just theory. It's how these laws actually get applied in the real world, to real families.
Okay, so this is where our story begins. Meet Kritika Jain. She actually filed a lawsuit against her own father and her aunt. And what was she demanding? A piece of the house that belonged to her grandfather. Her case puts our big question right in the middle of a courtroom.
Right, let's get the players straight so we all know who's who. The original owner of the property was the grandfather Pawan Kumar Jain. After he passed, his property became the center of this whole dispute. On one side, you have his granddaughter, Kritika, and on the other, her own father and aunt.
So, Kritika's whole case boiled down to this one single idea. She was convinced her grandfather's house was ancestral property. And because of that, she argued she was legally owed a 1/4 share just by being born into the family. Now, this is a really common belief, so let's dig into where it even comes from.
To really get what Kritika was arguing, we've got to jump in a time machine for a second. We need to look at the traditional Hindu law, the way things were before a huge legal change came along and basically rewrote the entire rulebook.
So, back in the day, under the old Mitik Shara school of Hindu law, this term ancestral property had a super specific meaning. It was any property that was passed down through the men of the family, from a great-grandfather to a grandfather to a father.
And this, right here, is the absolute key to the old way of thinking. The very moment a son was born, boom, he automatically got a stake in that ancestral property. It was a right by birth. This is exactly what Kritika was basing her lawsuit on. But as you're about to see, this tradition hit a major roadblock.
All right, now let's talk about the big one, the absolute game changer in modern Hindu inheritance law, the Hindu Succession Act of 1956. This piece of legislation didn't just tweak the rules, it turned them completely upside down. Just look at the difference here. It's night and day, right? Before 1956, that property could just keep rolling down the generations as ancestral. But after 1956, everything changed. When a son inherits property from his father, it becomes his own self-acquired property. It's his, personally. The ancestral chain is officially broken.
And the rule that made all this happen? It's called Section 8 of the Hindu Succession Act. It basically hit the reset button, creating a brand new, very clear order for who gets what when a Hindu man passes away without leaving a will. The law is super specific about who's first in line. They're called Class I heirs. And that list, as you can see, includes the son, the daughter, the widow, and the mother. But look at that note at the bottom, because this is absolutely crucial. Grandchildren are only in this top tier if their parent has already passed away. Since Kritika's father was very much alive, she simply wasn't a Class I heir to her grandfather.
Okay, so we've got the old law, we've got the new law. How did this all play out for the Jain family in court? Let's get to the verdict.
The court didn't have to look far. The Supreme Court has already laid down the law on this very clearly. The principle is this: when someone, like Rakesh Jain, inherits property from his father after 1956, it becomes his personal, individual property. It's not ancestral property for his own kids. He can do whatever he wants with it.
So, when the Delhi High Court looked at this case, it was pretty straightforward. They applied that exact principle. Since her grandfather passed away in 1994, that's long after the 1956 Act, the house went to his son, Rakesh, as his own self-acquired property, period.
So what was the final call? Well, Kritika's lawsuit was dismissed, completely. The court said she had no legal right, or what lawyers call a cause of action. Why? Because the entire foundation of her case, this idea of a right by birth, was wiped out by the modern law.
All right, that was a deep dive into some serious legal stuff. But what does all of this actually mean for you in practical terms? Let's break down the key things you really need to remember from all this.
This really boils it down to 3 simple truths you need to know. 1. Just because your grandfather owned it doesn't make it ancestral for you. 2. After 1956, when your father inherits that property, it becomes his personal asset. And 3. The big one, you cannot claim a right by birth to it. Your father has the right to sell it, gift it, or leave it in his will to anyone he wants.
This case really clears up a huge misunderstanding. But it also shows you how these old ideas about property rights are still floating around, and they can lead to really painful conflicts inside families. Which brings up a pretty important question, right? For something this vital, shouldn't we be doing more to make sure these laws are crystal clear for everyone, so maybe we can avoid these disputes in the first place?